Welcome to Immigration Info, your ultimate hub for all things immigration. Looking for visa tips, country guides, and the latest immigration updates? You're in the right place. Subscribe for expert insights and join our global community today. Employment status could jeopardize college athletes' student visas. For international students, pursuing higher education in the United States often comes with a myriad of challenges, one of which is maintaining their visa status. Among these students, athletes face additional complexities due to their involvement in collegiate sports. Recently, concerns have arisen regarding how their employment status, particularly related to compensation for their athletic endeavors, might impact their student visas. The dilemma for international student athletes. International student athletes enrolled in U.S. colleges typically enter the country on F-1 visas, which are designated for academic studies. However, their participation in collegiate sports involves elements of employment, as they receive scholarships, stipends, and other forms of compensation. While these resources are essential for their education and athletic development, they blur the lines between student and employee, potentially affecting their visa compliance. Visa regulations and employment restrictions. The U.S. government imposes strict regulations on F-1 visa holders regarding employment. While limited on-campus work is permitted, off-campus employment is generally restricted. The Department of Homeland Security, DHS, defines employment broadly, encompassing any work performed in exchange for compensation, including scholarships or stipends. Thus, the compensation received by student athletes for their participation in sports could be interpreted as employment, raising concerns about visa violations. Recent scrutiny and legal challenges. In recent years, the employment status of college athletes, both domestic and international, has faced increased scrutiny. Legal challenges have emerged, questioning the NCAA's amateurism rules and advocating for athletes' rights to compensation beyond scholarships. While these discussions primarily focus on the rights and welfare of athletes, they inadvertently highlight the potential visa implications for international student athletes. Potential consequences and mitigation strategies. Violating visa regulations can have severe consequences, including deportation, visa revocation, and future immigration restrictions. International student athletes risk jeopardizing their academic and athletic pursuits if their employment status leads to visa violations. To mitigate these risks, colleges and universities must provide comprehensive guidance to student athletes regarding visa compliance. Additionally, legislative reforms and clearer guidelines from immigration authorities could offer much-needed clarity and protection for this vulnerable population. The intersection of collegiate athletics and immigration regulations presents a complex challenge for international student athletes in the United States. While their participation in sports enhances their educational experience, it also introduces potential complications regarding their visa status. As discussions surrounding athlete compensation evolve, it is imperative to address the visa implications to ensure that international student athletes can pursue their academic and athletic aspirations without fear of jeopardizing their immigration status. Collaborative efforts among educational institutions, athletic organizations, and government agencies are essential to safeguarding the rights and opportunities of these students.